It's 10:30 on Thursday, the 12th of October, so time to start our pre-examination meeting for the proposed Earraghail wind farm. Our case reference is WIN-130-8. Got a few housekeeping issues just before we start the main meeting. Firstly, if you could all make sure your mobile phones are switched off or on silent mode. Your cameras should be switched on. Please remember to mute your microphones apart from when you're speaking. And if you have a question at any point, please raise your hands. There's quite a few people on the screen, but I'll do my best to spot you. The meeting today is being live streamed and it will remain available to view on the DPEA website. By participating today, you are consenting to that recording and to the storage and making use of the material for the purposes of webcast training, keeping records and making those records available to the public. My name is Tammy Swift-Adams. I'm a reporter with the Scottish Government Planning and Environmental Appeals Division, or DPEA. I and my colleague Karen Hayward, Assistant Chief Reporter, have been jointly appointed by the Scottish Ministers to conduct this inquiry held under Section 36 of the Electricity Act 1989. The application is for a 13-turbine wind farm with a solar voltaic array and battery storage. We'll be preparing a report to the Scottish Ministers on the application, and it's for the Scottish Ministers themselves ultimately to decide whether to approve the application. I'll be chairing the meeting today, but Ms Hayward's also present, and Lucy Wakeham, who let you into the meeting, will also be on hand to cover any technical issues that might arise. We'll be taking a note of the meeting today, so please bear with me if I need to pause at any point to just make sure I've got key points noted down. We will issue a meeting note that'll be within a week of this meeting, and that'll confirm the key procedures and the timeframes that we're going to agree today. The purpose of today's meeting is to discuss the arrangements for the inquiry. It's not itself a part of the inquiry. We won't be taking evidence or discussing the merits of the case at all today. You should have received a meeting agenda a couple of weeks ago. That sets out our initial thinking, hoping to progress through that agenda as quickly as possible, and I'm going to focus discussion on any items where there's a difference of views or where we need to come to agreement. I haven't scheduled a break. I'll review as we go along whether or not we're going to need one. Moving on to agenda item 2, introduction of parties' representatives. I'd like to invite the lead participant for each party to introduce themselves and the members of their team and indicate anticipate any additional witnesses taking part in forward processes beyond today. So could I start with the applicant, please?
Good morning, madam. My name is Colin Innes, and I'm a partner in the law firm of Shepherd and Wedderburn, and I appear on behalf of the applicant, Scottish Powers Renewables UK Limited. I'm instructed by Laurie Martin of Scottish Power Renewables legal team. Thank you.
Thank you. And the council, please.
Good morning, ma'am. My name is Maurice O'Carroll. I'm an advocate in Scotland. I'm representing Earraghail and Bute Council. I'm attending today with me is Arlene Knox, main planner behind the objection to this application. And in future, there will be a witness, Carol Anderson, in due course, who will give evidence on landscape and visual issues.
Okay. Thank you very much. Nature Scott.
Good morning, ma'am. My name is Cameron Gregg. I'm a senior associate at the firm of Morton Fraser. I'm appearing on behalf of Nature Scott. I'm joined here today by my colleague Judith Baxter, who's also on the call, and by the operations officer of Nature Scott, Claire Davidson. Other representatives from Nature Scott, I think, are watching the live stream. In terms of witnesses, we intend to lead Carol Anderson to speak to impacts on the National Scenic Area, and in terms of policy, our witness will be Catherine Harry of Nature Scott.
Okay. Thank you. And now Glasgow Prestwick Airport, please.
Good morning, ma'am. I'm Ewan Brown, an advocate in Scotland, instructed by Glasgow Prestwick Airport. I am accompanied this morning by Sarah Wardle and Victoria Ray. And going forward, the witnesses for the airport may include Stephen Thompson, who's the Manager of Air Traffic Engineering, Philip Smith, who's the Manager of Air Traffic Control, Kel Kirkland, who's an expert in air traffic control, Doug Fido, who is an expert in radar engineering, and Zoe Kilpatrick from the airport, who is the Commercial Director of the airport.
Thank you. Talbot and Skipness Community Council, please.
Good morning. My name is Rupert James. I'm a community councillor for Talbot and Skipness Community Council, representing the communities of Talbot and Skipness. I'm also representing Skipness Estate, a neighbouring land over the proposed development of which I have an interest. Thank you.
Thank you. And the Kintyre Way.
Well, good morning.
Sorry, I've got one more point. I should have introduced my my colleague Paul, who's also helping with the case on behalf of Talbot and Skipness Community Council. Excuse me.
That's all right. I'll uncross out your name, Paul. Okay. And the Kintyre Way, please.
My name's Bob Chicken. I'm a trustee of the Kintyre Way. And that's it, really.
Okay.
Thank you.
Thanks very much. So I think that's everybody we were expecting. We had invited North Arran Community Benefit Society to attend, but I don't think we've heard back from them. So I think everybody who's here today is everybody that's opted in. Okay, moving on to agenda item 3, the Code of Practice for handling inquiries under the Electricity Act. There are no prescribed rules for the conduct of inquiries held under the Electricity Act, so the DPA has published a code of practice for such inquiries that's modelled on the most up-to-date procedures that apply to planning appeals. It sets out rules to be followed and it aims to ensure that we conduct all proceedings in an efficient, proportionate, fair and transparent way. The code's available to view on the DPEA website and there's a link to it in the meeting agenda. I'll put one in the meeting note as well. Parties might want to refer to that code for further information on some of the detailed matters on procedures that we might address today. The code allows for flexible procedures with each matter for each inquiry being dealt with in the most appropriate manner. You'll see in the agenda and the appendices to the agenda that we've set out our initial thinking on how matters might proceed in this case. We'll discuss that under item 5. But for now, I'm just going to give a brief outline of some of the different methods that are available to use. Firstly, an inquiry session is the most formal of the available procedures, and it's particularly suited to topics where there's a lot of technical evidence. It's chaired by a reporter. Each party is invited to give evidence in turn, and that evidence will be cross-examined or questioned by parties who have opposing views. It's not essential to have a lawyer, but parties are usually legally represented, and it's those lawyers who cross-examine the witnesses. Although Ms Hayward and I are also likely to ask questions. A hearing session is a structured discussion that's led by a reporter, that would be me, with an agenda issued in advance. This procedure is less formal and it's suitable where there are differences of opinion on something which is a less technical matter. There isn't formal leading of evidence or cross-examination. Parties' lawyers can take part in those discussions, but legal representation is not required. I'd say at this point, all parties that do agree to participate in inquiries or hearing sessions should be aware that they need to prepare evidence in advance, submit that in writing. That's to allow any other parties to see what's being presented, so there's no surprises on the day. Further written submissions are where we ask parties to provide specific information in writing and then invite other relevant parties to comment on that. Site inspections also form part of our evidence gathering, and we'll cover that point in item 9 later. For some issues, existing submissions are likely to be sufficient and further procedures won't be required. Later on in the agenda, we'll go through the where we intend to use those different procedures in this case. So agenda item 4, updates. Main purpose of that is to clarify whether there are any fundamental changes to parties' positions or any significant additional information that might update the application. We've noted on the agenda 2 recent case decisions that address matters of relevance to this inquiry. We don't need to discuss those, but we wanted to draw them to parties' attention in case they were not aware of them. But just as a reminder, case WIN-130-8, Clockery Wind Farm, we flagged that because there's some commentary in there on aviation detection lighting systems. And WIN-130-2006, which is the Sanker 2 Community Wind Farm, we flagged that to note commentary relating to Prestwick Airport, Glasgow Prestwick Airport. Okay. Moving on from those points that were in the agenda, we understand there's a revised aviation lighting scheme that's been provided by the applicant to Nature Scott. Noting that we can discuss any consequential timescale impacts that might have under later items, could we just for now have the applicant's update on what's happening in relation to that matter, please?
Thank you, Madam. What I propose to do in section 4 updates is obviously to make you aware of other matters that are relevant to the matters that you've raised in the agenda. In terms of Clockery, that's a decision obviously that the applicant was involved in, and we're obviously currently considering the implications of that decision very carefully. But I do want to just raise with you that placing weight on the findings on the ADLS from that inquiry, things have moved on. And I think it's probably helpful if we're just to outline the extent of how that's moved on. The Clockery inquiry had a strategic study lodged at the time about aviation lighting and how it could be mitigated. And in that context, it was very much a proposal of the technologies available, and here's how the consultants considered it could be implemented within the UK regulatory framework. The matter has been further considered at the Carrick public inquiry, and the nature and extent of information is at a much higher level. And in addition, there's been ongoing consultation with the CAA regarding the implementation of this type of mitigation. And in that context, there is now progression towards actually having a trial of the technology in the southwest of Scotland. There has already been detailed stakeholder engagement which took place over the summer and is ongoing. In addition, material has been submitted to the CAA relating to the trial, including a trial plan and safety assurance documentation. The nature and equipment has been specified, and subject to CAA approval, the trial may commence towards the end of this year. And I just flag that up because it's obviously a very different position from that which was presented at Clockery, and represents my client's ongoing commitment to trying to provide effective mitigation to aviation lighting, as in terms of the solar turbines now being deployed in Scotland. So, as I thought was helpful just to set that out so that what you can expect. The trial may run up for up to 6 months, and against that context, the output's unlikely to be available. But as I say, where we're going and the direction of travel on this has moved on significantly since the Clockery inquiry evidence was considered some years ago.
Okay.
In terms of the second decision at Glasgow Prestwick Airport and Sanker, and no doubt GPA will speak for themselves, but again, that's a matter which is obviously still live in front of a conjoined inquiry between Knockcronnell, Craigmoddy and Carrick wind farms. And there is ongoing discussion about process and further consideration of the implications arising from both the Sanker and Clockery decision relative to the positions presented by Glasgow Prestwick Airport at both those inquiries. So that is ongoing, and as I understand it, there's correspondence and procedure discussions going on. So there may well be further matters arising in that context, which may or may not have a bearing in relation to consideration of this application. So those are just general updates, but I do have an important update which does have a bearing on matters here. And that is that at the beginning of this week, whilst reviewing matters relating to the EIA report, it's been found that there is an error in Chapter 3, Table 3.1, and it relates to the coordinates provided there for turbine 5, T5. The issue was that turbine 5 was slightly relocated towards the end of the process of the design of the wind farm, and effectively the coordinates in Table 3.1 were not updated. Now, over the past 24 hours, the team have been looking through the EIA report to see whether this has had any bearing on any of the findings of the assessment. And our initial review is that it has not, because effectively, in terms of the various chapter assessments, it's been checked, and T5, as set out on the plans, has been the basis of the coordinates that have been assessed. However, there may be, and we're looking at, you raised the issue of the reduced lighting scheme. We believe that the material that had been submitted to the CAA may well have incorporated the T5 in the wrong location, i.e. in the Table 3.1 coordinates. The implications of that are that we were seeking to work with NatureScot relating to the mitigation being offered in its entirety to one of the matters that they raised in relation to their objection in terms of nighttime effects. The consequence is that we will potentially have to go back to the CAA with the revised location to get reviewed approval of the reduced lighting scheme. So that's number one implication of the error in Chapter 3, Table 3.1. The second area of which we've also sought to look at over the past 24 hours is the extent to which any consultee may have utilised Table 3.1 in their consultation responses. And to date, we've identified the potential for Highland and Islands Airport, Glasgow Prestwick Airport, NATS, BT, MOD, and the JRC on telecoms. Other aviation consultees who responded to the application were Edinburgh Airport, Aberdeen, and Glasgow Airport. And there is the potential, a real potential, that those consultation responses were informed by the coordinates contained in Table 3.1. Now, in terms of taking matters forward, it's clear that this matter has to be cleared up and resolved adequately. At this stage, we will want an opportunity. As I say, we've done all this work over a 24-hour period to try and understand the ramifications, but also to help this morning, to try and find a way of resolving the issue and managing the process efficiently. In that respect, it's certainly the case that amending Table 3.1 could properly be described as additional information, and would therefore require to be formally submitted and consulted upon. But I think what we want to do in the first instance is to make sure that the applicant's material is not in any way infected by this error, to ensure that any other consultations have not in any way been hampered by the error in Table 3.1. We would then want the opportunity to make sure and identify any consultees that we think have potentially been impacted upon in terms of the consultation response. I think it would be very important that at the point of time of identifying or submitting formally the change table 3.1, that those parties were directly contacted with the as well as the consultation response, contacted to make sure that they have we explain the context and what has happened, and so that they understand that there may have been an error in their consultation and analysis of the original application, and what it relates to and how. So that's, as I say, the process. One of the implications also is that I say that we would have to go back to the CAA and look at that revised lighting scheme and get approval. And we would also want to lodge that at the time of any additional information. So, as I say, I think that in terms of a process, the applicant first will review all its assessments, perhaps having slightly more time than 24 hours to make sure that nothing is awry. Secondly, to identify what we believe is a comprehensive list of those consultation responses which we believe may have been impacted upon by the material or the error. And third, we also come back to you as to any document that we have to modify in light of this and a timescale for delivering it. And we obviously, in some respects, will be in the hands of third parties before we can work that through. But it doesn't seem to me at this stage to make sense to have multiple lodging of additional information. It should be done once. So we should be amending the table 3.1 to be correct. And secondly, if there's any material that the applicant has to change, it should be lodged at that time as well, so that it's consulted upon at that time with the correct information. And thirdly, at that point, time will have to be given to those consultees to respond. And I think the standard timescale is 30 days from the lodging of that material. So in terms of a process, I think the applicant has to sort out its position. It then needs to lodge the position with you. And thereafter, there has to be the appropriate time period for the consultees to respond to the matter and to ensure that we have dealt with the matter appropriately and fairly. And I would add also, in terms of the reduced lighting scheme, there may also be further information that we were going to submit in relation to the response to the Woodland Trust's representations to the application. And we would do potentially lodge that material at the same time as well. So there would only be one set of additional information coming forward, and that we weren't constantly lodging material that potentially had to be advertised or reconsulted upon. It is very regrettable that this has happened, but I think it's important that as soon as we realise that we have tried everything possible to understand the potential consequences that the error in table 3.1 may have, and also to find a solution for getting the material in the correct format for the public inquiry process.
Okay. So just so make sure I've got the key points noted down, all in all, the potential package of additional information will be corrected table 3.1, any consequential material replacements that are needed in consequence to that, the reduced lighting scheme information, and a potential response or updated information in response to the Woodland Trust's outstanding objection.
Yes, madam, that's the list. Thank you.
Yeah. And if that's all coming in as a single package of information, we've got, so I've got an initial timescale at the moment based on the information that we've got, the normal process. We'll come on to looking at the forward timescales under a later item, but do you have an idea at the moment of when all of that information is likely to be available to submit?
Madam, the difficulty I have with timescale is we need to find out how quickly the CAA may be able to turn around a reduced lighting scheme. And so, I mean, realistically, probably a month is the likelihood in terms of timescale as a minimum. But what I would want to caveat is that if we find any other assessments been impacted upon by this, then it could have implications of that chapter having to be redone if that assessment in the chapter, and it could result in that chapter having to assessment being redone, and potentially the chapter. The likelihood of that happening is low, given the relatively low movement of T5. You can, until you've done that exercise, I can't give you an absolute guarantee. So, but I do think in terms of a process where it involves a third party, promising anything in less than a month is probably unrealistic.
Okay, so at least a month, and only then if no significant consequential updates are found to be required. Okay. Obviously, I'm asking this because a key output of today's meeting ideally will be a timescale, a full timescale for the inquiry. So we will see when we get to that item whether that's something we can still achieve. Ms. Hayward, do you want to?
Mr. James, question.
Okay, I'll bring in you now, Mr. James.
Would the applicant's representative please confirm for the communities that the positions of the turbines as they are shown on the design freeze in the maps within the EIA is correct?
Yes, comments about the applicant. That is my understanding based on what we have verified over the last 24 hours. And we're fairly confident about that position because we realise that's an important matter. So yes, we're fairly confident on that matter. Thank you.
Thank you. And is that Nature Scott's hand up?
Mr. Brown, I think.
Mr. Brown.
Thank you, ma'am. Yes, I'll keep this brief. I think it's perhaps appropriate just to say a few words in response to some of the comments which Mr. Innes added there regarding the airport's position. First of all, so far as Sanker 2 is concerned, the airport is reviewing its position in relation to that determination. But separately, as the applicant is aware, there is an ongoing review of the technical and regulatory issues which have emerged as a result of the Sanker determination as it currently stands, and the CAA is also involved in that process. Separately, there are also additional technical issues and indeed regulatory issues which have been identified by the airport since the determination in Sanker has been issued. And I flag that up now, ma'am, just in light of the discussion there with Mr. Innes about how long it may take for the applicant to obtain the CAA's input. The airport is in a similar position in that it also awaits discussion and input from the CAA so far as the further regulatory and technical issues are concerned.
Thank you. Do any other parties want to make any comments or ask questions on the points that have been discussed so far?
Nothing from me, ma'am.
Okay. So as I say, we will come on to timescales later in the agenda and see what we achieve there.
Sorry, ma'am, if I could come in just with some brief comments. In terms of the proposed, the reduced aviation lighting scheme, I did have a request that I was going to make. I appreciate that's perhaps a bit up in the air now, given Mr. Innes's update. But if there is to be a reduced aviation lighting scheme, there's a number of items which Nature Scott would appreciate if they could be included as part of the additional information. I wonder if I could list those for consideration just now.
Yeah.
So, firstly, it would be very helpful to get an updated ZTV of the reduced scheme. would be very helpful to get an updated list of the numbers of the nacelle lights that could be seen from the LVIA viewpoints, including the viewpoints, the additional viewpoints that were submitted in February this year. And finally, it would be very helpful to get new lighting visualizations showing the aviation lighting from 3 viewpoints. That's viewpoint 8, the Cock of Arran, viewpoint 9, Loch Ranza, and viewpoint 18, Mulach Bui.
Thank you. The applicant able to comment on that?
Thank you very much. I think you might, that might well have been where we discovered the issue relating to turbine 5 was we were in the process of preparing the information because we had been in dialogue with NatureScot in relation to matters. So yes, that material would be supported by those matters, and that's why it's of some import that we get the matter resolved sooner rather than later, because there is visual material that is on the back of that.
Okay. Thank you very
Mr.
much.
Can I just ask, is there potential for this error to have had a material impact on the visualizations that have been prepared to date? No. Thank you.
Thank you.
Just add one thing for the council. I've heard that there's been correspondence between the applicant and NatureScot, and that's correct. But I don't think that we've been equally kept up to speed from the council's point of view. So I just simply want to underline that we would be also included with any information that might have an effect on aircraft lighting visualizations, because of course that forms part of the council's case as well.
If that's coming in as additional information, then that would be, everybody would have an opportunity to comment on that.
I would hope so.
I'm going to move on to cumulative landscape and visual impact assessment. So that's part of an application that can evolve. Is there any requirement in this case for parties think to update the cumulative landscape and visual impact assessment to take into account any additional wind farm proposals at application or scoping stage, or any change in status of any proposals that are covered in the existing assessment? Could I ask for views on that, starting with the applicant, please?
Our position is that we believe that the application material is fit for purpose and would work at the current date, but we do need to probably agree a cut-off date, or otherwise it's a never ending. And we propose that that cut-off date should be today.
And at today's cut-off date, you think the current assessment stands?
Yes.
Yeah.
But of course, we're not party to the same information that either the council or NatureScot have, but as we understand it, it's good on the basis of the information that we have.
No, and I'll seek comments from other parties now. So the council, do you have any views on that?
The extent to which other schemes would be included in the cumulative impact assessment has already been a matter of discussion, and I don't think I have anything further to add. Simply to note that, of course, the case of Sheardrum was refused, and that therefore doesn't form part of it, but obviously that's part of the mix anyway.
Okay. Do any other parties have any comments on the cumulative LVIA? No. Okay. So are there any other significant updates that we need to be aware of beyond those we've discussed so far?
Just one other from NatureScot, ma'am. Perhaps not an update of as such, but I wonder if this is an appropriate time to raise this. It's just in relation to biodiversity enhancement. So this is obviously an important new policy area in National Planning Framework 4. It's something which reporters are starting to grapple with, and it's a topic of considerable interest to NatureScot. Now, it's not the a ground of objection for Nature Scott at this inquiry, but and there are assessment methodologies and metrics that are being prepared behind the scenes and aren't quite available yet. But Nature Scott do wonder if it might be helpful if they were to prepare a brief written submission on the topic for the benefit of the reporters here in order to assist you in approaching that policy. So they'd be happy to do that if that would be helpful.
Okay, so we're going to come on later to, or now, in fact, to the topics requiring further procedure. So that is maybe one that we could discuss within there's a proposal for a further written submissions on ecology, but probably more relevant is a potential hearing on energy and planning policy. So if it's a view on that aspect of national planning policy, it might fit within that. Okay. So if there's no other major updates, I'll move on to that section then. Okay, so agenda item 5, the provisional assessment of topics requiring further procedure. So our report to the Scottish Ministers will take account of all of the environmental information that's submitted, together with all of the consultation responses and the representations that people have submitted to the Scottish Ministers, whether or not a topic is one of those that we're suggesting for additional procedure. It's not indicative of its relevant importance. It's just looking at where we think we might need more information and the most appropriate way to go about getting that additional information. In Appendix 1 to the agenda, we have set out the topics that we think we may require either an inquiry session, hearing a session, or further written information on to inform our report. And in Appendix 2, there's our preliminary thoughts on the likely matters to be considered within each topic. So that's just a preliminary thought, and we can narrow that down now if necessary. I'm going to seek parties' views on each procedural suggestion as we go through them. We'll get on to participation in any oral sessions, timings, etc. under items 6, 7 and 8. So we're not looking to discuss those details for now, just the topics themselves. So I'll start, as set out in Appendix 1, with proposed inquiry session on landscape and visual impact, including the visual impacts of aviation lighting. We've set out in Appendix 2 a long list of the matters that might include. So if you have that to hand, that will help, because we maybe can narrow that scope down a bit. At this point, it would be useful to know parties' views on whether that's an appropriate approach to considering landscape and visual impact, both in terms of the principle of having an inquiry session on that topic, and if so, whether all of the matters that I have listed are need to be within the scope of that session. Could I start with the applicant's views on that, please?
Yes, thank you, Madam. Yes, we think it's very comprehensive. We agree the landscape and visual impact session would be appropriate. I think, given past experience, there will be a lot of value in seeking to try and reach a measure agreement between the applicant, the council, and Nature Scott over matters, and so that you have a very clear picture of what's agreed and not agreed up front, and that the inquiry session can at least then focus on matters in dispute. And certainly in the past, we've worked effectively with both the council and Nature Scott in that regard, and I think there would be a lot of value in trying to reach as much agreement as we can in relation to those matters, and it then becomes, I think, a lot easier to then focused evidence as opposed to going through things which should be potentially agreed. So we agree with the process and think that statements of agreed matters would be an important way of helping that session.
Thank you. And we'll programme statements of agreed matters into the timescale later on. Could I take the views from the council, please, on that inquiry and list of topics?
Thank you, Mum. Yes, I agree. Inquiry session would be appropriate for landscape and visual impacts. I also agree that the topics there set out would be appropriate ones to be covered and to be comprehensive. I also agree with the sentiment expressed by Mr. Innes that a matter of agreement could be reached in certain matters in advance of that to narrow down the scope of disagreement between the parties. That's something that the Council habitually does, planning inquiries. Nothing else to add.
Thank you. I'm going to hear from Nature Scott, please.
Yes, ma'am. I also agree that a statement of agreed matters could be helpful here to focus the issues in dispute, and the Nature Scot's interest will, of course, just relate to the national scenic area. In that regard, I wonder if there might be something to be said for splitting the landscape and visual effects inquiry session in two. One session to deal with the impacts on the national scenic area, and one to deal with the wider LVIA. So I just suggest that for consideration.
Okay. Do any other parties have comments, either in general on this inquiry session or on that suggestion of a split? Any hands up? Mr. James? You unmute still, Mr. James.
Apologies. The communities would appreciate being circulated or included in any advanced agreement on agreed matters. And we do have a contribution to make in this area. Thank you.
Okay. So the statement of agreed matters would get published on our website. So that'd be a public document.
Okay, we wouldn't be invited to contribute to that. Is that correct?
I'll ask the applicant. So your suggestion was that that would be between the council, the applicant, and Nature Scott. Do you have any comments on the idea of community groups being invited to?
It's quite, the issue is that you've got to set, I mean, the primary purpose of a statement of agreed matters is where parties have set out fairly comprehensive cases we're trying to agree methodologies and other outcomes. The more people you put in, the less likely it is to reach a manageable document. That doesn't, I mean, it is an open document. Normally, quite often, a statement of agreed matters will be between individual parties. And depending on the way that this goes, if you split the inquiry sessions, I would probably be suggesting that the statement of agreed matters probably gets split. So it may actually be that we do one with the council and one with Nature Scott, because that's the better split if we split the inquiries. In those circumstances, it's really, we're happy to reach out and to have a discussion about what we can agree with the community councils. But I'm not sure that it helps to creating more parties to a statement of agreed matters. We're happy to say and copy in and say what we're doing and see if they're interested in participating and trying to agree something with us. But it depends on putting time into that process. And if they're prepared to do so, we could see how it works. It's not something that's forced. It's two parties who come together and agree. So if it doesn't agree or it doesn't work, then it doesn't work. So it's a part of a process where you start off saying, we want to narrow issues and we want to identify the process. We're happy to give it a go, but it is work. And just to be clear, there is a time commitment and timescales, etc. But we're happy to give it a go. I'm not so certain that I would want, or we would suggest, breaking it up, because as I say, if we break up inquiry sessions, I think we'll be quite focused in getting a statement of agreed matters between the council and ourselves and Nature Scott themselves. Now, it may well be that arising from that, if the community council are engaged, that they might choose to align themselves with agreements that were reached. But we do need to really focus on getting those initial agreements, but we're happy to also seek to agree with the community councils if that's what they want to do.
Okay. Well, we will consider the request from Mr. James in relation to the community council and the suggestion from Nature Scott in terms of whether that's a single inquiry session or split, and we'll set out a decision on that in the note of the meeting.
Can I just ask before you go any further, Mr. O'Carroll, what does the council think about splitting the inquiry into two?
Yes, I was. Thank you, Mum. I was trying to raise my hand earlier to make a comment on that. As you'll be aware, obviously, that Carol Anderson will be giving evidence in relation for two parties, both for the Council and Nature Scott. Council's made it clear that its focus is on the NSA. So one could see that there might be a benefit in splitting her evidence in that way, so that her evidence is in a discrete portion when it's given on behalf of Nature Scott and separate from that given on behalf of the Council. And I can see the merit in that. My concern, however, is of a much more practical one, born of experience of these things in the past, in that there's inevitably overlap in matters. And whichever way you're looking at it, it's landscape and visual impact evidence overall, with the target of one being at the suggestion of Mr. Gregg. So I think in principle it sounds good, but I do wonder if there may be an element of duplication which will necessarily be involved when you're getting into matters like that, whether or not it's actually something that's capable of being discreetly divided up in that neat fashion that would otherwise sound quite attractive. I'd simply offer that as an observation.
Thank you. Does anybody else want to come in and ask any question or make a comment on what we've discussed in relation to this inquiry session so far?
Just very briefly, ma'am, just to come back on Mr. Carroll's point. Yeah, I entirely appreciate the concerns regarding overlap. My own view is that although the impact of the national scenic area is, of course, informed by landscape and visual impact, it can be discreetly cut off from that separated into a separate session, but it's not a major point. If it's easier to have the session combined, that's fine. But I just thought it might be lead to a more streamlined process if we were to split it. But I'll leave it to your discretion.
Okay, and as I say, we can think about that. I mean, if there's anything on that long list at the moment that jumps out as being difficult to split, it might be worth just having a quick look and flagging that now. A lot of it is location specific. Is there anything on there at the moment that parties would suggest points to an easy or difficult split? That's fine. We'll look at that ourselves, and as I say, confirm in the meeting note. Just one other thing I was going to clarify before we move on. For Mr. James's comment regarding the statement of agreement, is just to clarify. So you're representing Tarbert and Skipness Community Council. So it's just the one community council you're making that suggestion on behalf of.
Yes, at this stage we're in discussion constantly with East and West entire community councils who have also issued objections, and in some capacities we are carrying forward their objections and the issues raised within our own argument, but largely for reasons owing to the workload put upon them with numerous other applications, they are unable to participate themselves. But we are in regular discussion with one another.
In terms of an additional
sharing that, any information would be shared with them, and we would seek to consult with them, yes. That answers your question? Yep.
Yeah, thank you. Okay, I am going to move on to the second inquiry session, which we have proposed, which is inquiry session on aviation safety, particularly radar impact, and that would focus on operational impact on Glasgow Prestwick Airport. As before, we'd like to hear parties' views on having an inquiry session on that, and starting with the applicant, please.
Yes, madam, we agree that an inquiry session would be appropriate for that matter.
Okay, and the council?
Well, I know you wanted to discuss participation later, but I think the council has very much a neutral view because it doesn't think it should be party to that particular inquiry session anyway. I think it's a matter of expertise, which is held obviously by Glasgow Prestwick Airport in relation to that, a matter of interest to them. It's not a matter that has been part of the objection from the council, so we would not seek to be part of that inquiry process. But obviously if the reporters think that an inquiry session is necessary, then we'd be neutral about that.
Okay. And Glasgow Prestwick Airport?
Thank you, ma'am. Yes, an inquiry session is considered to be appropriate for that. The only small point I would observe is that it's marked as being aviation safety radar. In fact, the issue is wider than that. It's about degradation in the airspace generally and the adverse effects on communication, navigation and surveillance systems at the airport, which certainly includes the radar, but it also includes VHF communication.
Okay, thank you very much. That's helpful. I'll note that down. So do any other parties have comments on whether inquiry is appropriate on the aviation matters that we've discussed? It's not about who would participate at this stage, just if anybody has a view on that. Yeah, Mr. Innes?
Yes, I've got one matter I want to raise in relation to the aviation session, and that is, in my submission, it would be more appropriate for Glasgow Prestwick Airport to lead their evidence first. This inquiry is an inquiry into objections, and insofar as that session is concerned, what we are primarily hearing about is the concerns of Glasgow Prestwick Airport on their operation. And the correct formulation of how that evidence should be given is that it should be the airport that sets out what concerns they have, and it should be the applicant that responds. I know this may sound or is perhaps less than the traditional way, but historically, in some occasions, where objections are technical and relate to a single party, and they have the technical knowledge and are leading it, it can be more appropriate for the airport or a technical body to give their evidence first. And in the circumstances, given the experiences that we've had of other inquiries involving this party, we would submit that the best way of getting the evidence is to have the airport to give their evidence first and for the applicant to respond to that evidence. And as I say, in my submission, you can read their objection. This relates to their technical aspects and appraisal of the application. And it's far better that that comes out first and is tested before the applicant effectively has to respond to that technical information. So, as they are experience, we would submit that that's the better way of gaining the evidence on this matter.
Okay, thank you for that suggestion. Does the airport have a comment on that?
Yes, thank you, ma'am. As Mr. Innes has said, that's not the traditional way to approach these matters. It's a matter on which I would require to take instructions. I'm not able to do that this morning, but perhaps it could be left on the basis that the applicant's view is noted and the airport will respond, ma'am, with further comments on that after today.
Okay, I'll note that as the position, and if you could respond as soon as possible, that would be helpful. As I said, I think I've said already, we're hoping to issue the meeting note within a week. So if we know your view within that, we can perhaps record that or communicate that at the same time. Okay, I'm going to move on, unless anybody else has anything to say about the aviation inquiry session. No, I'll move on to the hearing sessions. So we've proposed 2 hearing sessions, one on energy and planning policy and one relating to conditions. I will start with taking any views on the proposition to have a hearing session on the energy and planning policy, starting with the applicant, please.
Yeah, thank you, madam. I think it would be extremely helpful. And I suppose we note that in the bullet points there's nothing on energy policy, and certainly energy policy, given it's a Section 36 application, should probably be encompassed. And also there may be developments in energy policy, depending on what happens over the next period. So I think energy policy should potentially probably be in the bullet points. And I suppose we're also getting a body of decision making as well, which reflects the ministerial decision making against the context. So those we agree with the list, and we also agree that the National Scenic Area regulatory and policy framework is a matter of a specific topic within that would be worthy of exploration and understanding. So we agree with the suggestion of a hearing, slightly extended to include energy policy. And again, here's an area where there may be scope for agreed matters between parties as opposed to having a debate on lots of matters. So again, there's potential scope here for agreeing what's most relevant. And again, we'd be keen to work with other parties on that.
Thank you very much. Could I take the council's views on this session?
That's all agreed. I have nothing to add.
Okay. Do any other parties have anything to add?
Can I just ask Mr. Gregg, Nature Scott mentioned earlier about the provision of a statement on enhancement of biodiversity. And Mr. Adams mentioned that this could be where this fits. Are you intending to take part in the energy and policy planning hearing session?
Yes, ma'am. Nature Scott would certainly wish to take part in the hearing session on policy. In terms of biodiversity, that is something that could be covered there, but we do think there would be merit in setting out the latest in connection with where biodiversity enhancement sits and the relevance to this case in a brief written submission in advance of that.
Could I just ask the applicant to respond to that, please, Mr. Innes?
Well, if Nature Scott are going to be involved and giving some assistance on biodiversity, we would welcome the opportunity to respond to it. And I think if it came earlier rather than later, that would be very helpful. It's obviously a matter which is of ongoing development in relation to matters. So at the end of the day, the Scottish ministers will get your report. They will have to take into account the latest position. So we do recognise that if matters progress, we will need to potentially have that before the ministers. So I think it is helpful that Nature Scott provide that information.
Thank you.
Thank you. Okay, moving on to the other hearing session, which would relate to conditions. Irrespective of any recommendation that we come to make, the Scottish ministers will require a full set of conditions to be provided. It's usually the case that the applicant would liaise with the relevant parties to prepare a set of conditions. And we note that various consultees have suggested conditions within their earlier responses to the ministers. The proposed conditions hearing session would be focused on any conditions upon which there's still disagreement. Discussions on conditions would be without prejudice, to made on a without prejudice basis. We might also need some further written submissions on conditions from some of the relevant consultees. So with that in mind, could we hear views on having a hearing session on conditions? And within that, it'd be helpful to know if there's been progress made so far on any discussions relating to conditions. So again, I'll start with the applicant, please.
Yeah, we were waiting to set the timetable today, and we will and have done previously engaged extensively with Earraghail and Bute Council over conditions, and we're very confident that we've made meaningful progress in those discussions, having had relatively recent examples, which perhaps helpfully form a starting point to those discussions. So we're happy to be in the position of having to kick that off with the council and seeing how far we can get, and agree that a hearing would be the appropriate way of potentially resolving matters should that not be resolved. Quite often they're quite focused these days, the conditions session, but I think it provides a useful forum in which, as reporters, you can test whether we've actually met what the consultees have asked for. And obviously we had the challenge of trying to get a draft of meaningful conditions that all sit together, as opposed to conditions being thrown in isolation. So there is that balance being struck, and the conditions hearing session often finds that an appropriate forum in which to test that. So we agree that we think that's a good idea.
Thank you very much. And the council, do you agree?
Yes, that's all agreed. I have nothing to add.
Okay. Any other comments on hearing? We'll come on to participants later, but any other comments on the principle there?
No, agreed.
The airport.
Sorry, ma'am, I'll reserve comments for participation when it comes to that part of the agenda.
Okay, yeah, we will come on to that soon. Thank you. Okay, I will move on to further written submissions then. As set out in Appendix 1 of the agenda, we had identified some topics that could potentially be addressed this way. They include ecology, specifically relating to ancient woodland, Tarbert Woods, SAC, archaeology and heritage, particularly relating to West of Scotland archaeology, noise in relation to the status of some derelict buildings in the vicinity of the site, and socioeconomics, recreation and tourism, specifically relating to the Skipness estate. We're not now proposing further written submissions on peat, which is also on that list, but I'll come on to explain that. But ecology, we've discussed the Woodland Trust already, so it may be that what we had in mind in terms of questioning updates on the position of the Woodland Trust will be covered by your discussions and forthcoming additional information. Mr. Innes, is that?
Yes, madam, I think that would probably assist, and if there are any outstanding questions arising from that, then the further written submissions would be an opportunity for any clarification or information to be sought.
Okay, I'll note that down. And a second potential purpose of a further written submission relating to ecology would be if there is likely to be any additional information needed beyond that which we already have in order to inform the appropriate assessment that the ministers will need to undertake in relation to Tarbert Woods SAC. So could I take views on that point, whether a further written submission is necessary or helpful on that? Starting with Mr. Innes.
Well, we set out our position in the EIAR. Nature Scott set out their position in their response, which appears fairly unequivocal that with appropriate mitigation, there would not be an adverse effect on integrity. But if there are any matters arising out of the EAR or the Nature Scott consultation response that you feel you would benefit from further information on, then clearly we would endeavour to provide that. But I think it's a question ultimately of Nature Scott have said that they believe that appropriate assessment is required, and therefore your report to ministers requires to cover that off. And therefore, I suppose at this stage, it's making sure that you have sufficient information on any of the matters raised either in the EAR or in the Nature Scott response to be satisfied that you have the information to be able to write that up in terms of the report. We think that the information's there, but obviously you may want further clarification of that, or indeed the mitigation, how that operates, because that's obviously part of the reasons why Nature Scott was able to respond in the manner that they did. They were placing reliance on mitigation that was being offered as part of the development.
Okay, and I've got noted here that Nature Scott have said that on the basis of the information provided to date, if the proposal was carried out strictly in accordance with measures outlined in Draft Construction Environmental Management Plan and mitigation detailed in section 10772 of EIAR Chapter 10, the proposal would not adversely affect the integrity of the site. The question is really being raised because that was on the basis of information provided to date. We just wanted to check that. Well, I'll ask you, Nature Scott, is there anything else you're anticipating?
I think Nature Scott are generally content with where matters stand in connection with the exchange, but obviously if there's any further questions or queries which the reporters have, Nature Scott will be happy to address that in a further written submission. And if anything arises from the additional information that's being prepared in due course, that can be addressed as well.
Okay, Mr. James, your hand's up.
Hello, yes. The Tarbert and Skipness Community Council are of the opinion that Nature Scott's interpretation of the guidance surrounding the proximity of the turbines to the protected habitat is not entirely correct, and we wish to submit additional evidence in this regard. So therefore, we believe that a written submission at the very least is necessary. In fact, we are recommending some amendments to the agenda, which I maybe will list now. We actually believe that chapters 8 on ecology, 11 on archaeology and cultural heritage, and 14 on socio-economics, recreation and tourism should all be addressed by at least a hearing session, as it is perceived that the cumulative negatives of these is intensely pronounced from the perspective of the communities. And we're aware there's a huge additional written workload for us to provide evidence of what is already obvious from within the evidence presented within the EIA. The absence of, we find, for example, historical environmental Scotland's absence from the proceedings for the Earraghail wind farm disappointing, and we find their position conflicted and their non-objection somewhat confusing. So we believe that there should be a hearing session on these issues. We are also suggesting an additional inquiry in relation to the issues of ethical misconduct relating to unlawful and immoral survey and consultation procedures and the potential misuse of personal data highlighted in Skipness Estate's objection should form a basis for a further inquiry. We are requesting that the above amendments to the agenda are enacted or considered. We've produced a written document summarising what we are recommending and providing grounds for our arguments, which we would like the Scottish reporters to consider. A few things I've got here. I could even read it for you. We do not consider it appropriate that the issues recommended here are...
Don't read it out in full.
No, okay. We've got it in writing and we'd like to submit it to you so it can be considered.
Well, the purpose of the meeting today is really to identify what we do in terms of procedure. So we have the opportunity to discuss that today. So the appendix 1 to the agenda that we set out has our suggestions for which topics need further proceedings, and we're going through those at the moment. So you've come in at an appropriate point. You're suggesting that ecology should be a hearing rather than a further written submission. That's correct.
Is correct. That is one. That is, okay. If you want to do them sequentially, we're happy with that. Yeah, that's what we're suggesting.
Yeah, you just make sure we don't get things mixed as we go through. So you're suggesting, because you have concerns regarding the information before the inquiry, that there should be a hearing in relation to ecology. So I'm going to ask the other parties what views they have on that, starting with the applicant.
Well, we agree to written submissions on matters that arise. We think that's an appropriate level to deal with the matters. We don't immediately see the value in having a hearing, and we're very comfortable where the position is in relation to these matters. And it's really for parties suggesting whether there's a hearing to make the case as to what the dispute is and the detailed nature of it, to justify why we should be essentially hearing evidence, which, essentially these matters have been reviewed by the relevant bodies, and they've equally been very forthright in their views in the consultation responses. So if there's to be a hearing, there needs to be a reason as to why there should be a hearing and why further procedure is required in relation to the matter. It's not just as a topic I'd like to discuss. I think it needs to go further than I'd like to discuss it. What is it and why does it need to be resolved through a hearing?
Okay. And Mr. James, on that, are you able to give specifics as to why there are matters that require to be discussed at a hearing that couldn't be dealt with by further written submissions, rather than just the overall picture that you've given?
Yes, we would be able to do so, though we would need some significant time with which to prepare that. I remind you that we are unpaid people working voluntarily in our own time. We have amassed a certain amount of evidence, and we're looking for an appropriate platform with which to deliver it. And we would prefer to be able to field questions to consultees on these matters. Essentially, the only area in which the public have been given the opportunity to inquire is in the area of landscape. And we believe that we should have the opportunity to inquire in other areas because of the pronounced impacts on the natural and cultural heritage of the Kintyre landscape. So we are looking for more opportunities to cross-examine the statutory parties than we have been provided with. We're expected to provide an awful lot of written information on a vast range of subjects, but we're not given the opportunity to cross-examine the applicant or the statutory consultees on these issues. And the workload is increased by the absence, in our view, of important authorities, including Historical Environment Scotland, and so far no proper authority to comment on the historical landscape. So, you know, we would need good time to do that, but yes, we do have a sound basis for it.
Okay, well, you are down as a party for any further written submission that we have on ecology. I'll note your suggestion that you want to have a hearing, but we will need to take a timely decision on how we deal with that matter. So there isn't time to go away and then consider, give a further period of time for a case to be made on that. We'll base that questions today.
We can put forward what we've produced here, our written submission for you forthwith. You can consider that. That sets out basically some of the basic grounds for our requests. To provide the full range of evidence that would take more time, and we would assume to do that just preceding the hearing session. Any written submissions we would expect to be given good time, and for the dates of those submissions to be not significantly before the inquiry itself, to give the time to prepare the work.
So I'm just to be clear, I'm not asking or suggesting that we should be having any evidence of detail of the topic today, just the case for why it needs to be dealt with at a hearing. So we'll consider that suggestion, and then we will confirm in the meeting note whether that topic is going to be dealt with by further written submission or a hearing or by some other means. That's how that process works in relation to choosing how to deal with each topic. The actual evidence on each topic is separate.
Yes. Okay. We're simply saying that we believe that in these areas of ecology and also archaeological and cultural heritage, there are very pronounced impacts. We've already provided quite good evidence in our objections of these. We consider these to be more significant than in most consented, or if not all consented, proposed and even rejected applications. So we feel, that we need a good platform with which to make these arguments, and potentially simply providing further written submissions and not being able to cross-examine others on the matter is insufficient. Yes, we can. All I can really say is that I can submit you what we've written to be considered, and if you can provide us with a platform and outlet to do that, we'd greatly appreciate it. We're requesting we're stating that if the reporters do not wish to enact the changes or if the opinion addressed in this letter are irrelevant to the inquiry, we request a written response explaining the decision. So it's in the letter, and you can decide how to proceed from there.
Okay, and as I say, we'll confirm in the meeting note what we think the appropriate procedure for each topic is based on the discussion today, and we'll come on to some of those other topics that you've mentioned because they are on the list of things we've got questions on.
Thank you very much.
Okay, so Peat was the next one on the list. As I said, we don't now think we need to have a further written submission on peat. That was down because we had noted from the Council's committee report that at that point there were outstanding comments being awaited on from Ironside Farrer. However, I've found confirmation within the wider inquiry documents that Ironside Farrer's questions have been resolved. So we're not proposing a further written submission specifically on peat and Ironside Farrer's questions. Moving on to archaeology and heritage, we did note that there was a response from Historic Environment Scotland on file, but Historic Environment Scotland doesn't cover all historic environment assets, including unscheduled archaeology. We note from the Council's committee report that it wasn't able to form a full response on archaeology and heritage because West of Scotland Archaeology have not provided a consultation response. On that basis, we're proposing to ask that body for its comments, and that would be the focus of this further written submission process. Can I take comments on that, starting with the applicant, please?
Well, thank you, Madam. In terms of WOSAS, I think they're contracted to the council. So, in effect, you'd be asking the council to essentially give further material. And that's entirely a matter for you if you need further information. But they've set out their position in relation to this application in a formal consultation response. But I think your concern may be that you lack information on perhaps non-designated assets that weren't covered by Historic Environment Scotland's consultation response. And I suppose the initial point would be, did WOSAS ever get back to the council? And if so, is that information available? But this is a matter between effectively you and the council, I think, as opposed to WOSAS, because WOSAS is, as I understand it, technically contracted to provide advice to the council, as opposed to being a party that would be directly written to in the manner.
Okay, thank you. And does the council have any comments on that?
I'm just seeking instructions with regard to that matter, so whether or not WOSAS got back to the council.
Sorry, Mr. Carroll. No, I don't believe we've had anything yet.
So in that case, then, if you require further information, we could seek to obtain that from WOSAS if it was then required, and provide further written submissions if that's a matter that requires further clarification for the matters that Mr. Ennis has set out.
Okay, so although there's a link with the council, a further written submission would still be the right process.
The correct mode, yes, indeed. Yeah.
Okay, and I have got Community Council, Mr. James, noted down as a potential participant for that, so it's not something.
Yes, we would be. We will participate in whatever capacity we are permitted to do so, and we would encourage this area, cultural heritage, archaeology, to be also potentially a hearing process because of the pronounced impacts. But we will participate by writing if that is what is presented to us.
Thank you very much. Thank you. Any other comments on this topic? Okay. Turning to noise, the reason we've noted a potential further written submission on noise, again, this is something that has come from the Council's committee report. We note the Council has an external noise consultant who has given advice on the basis of the information available so far, but who has noted that there are some derelict buildings within 2 kilometres of the site boundary. It appeared that there wasn't a clear view at the time on whether or not those should be given residential status and assessed for noise impact. So the purpose of a written submission would just be to seek clarity on that point. Does anybody have a comment on that? I'll start with the council on this occasion.
That's understood. We'll provide further written submissions on that point, ma'am.
Clarify that. Okay. And the final written submission process we'd suggested is under the banner of socioeconomics, recreation and tourism. But that was specifically to seek information on the status of the Skipness Estate ecotourism and high biodiversity agroforestry project. That's mentioned in submissions. So we were keen to get an up-to-date position on that in writing. Is that something you'd support, Mr. James?
Absolutely, we would welcome that. Yeah, we're very grateful for that opportunity. I'd also make a comment in relation to the previous point regarding noise on the status of derelict buildings, because that a derelict building forms part of our application process, so that any information, data regarding the noise and the sound impacts are of immense importance to our proposal and our application. So we would insist on being party to any discussion and information on that regard, as well as any survey and consultation process and the data it produces, and any figures provided by the applicant on the potential impacts. We would want to be party to all that information. We're requesting to be so.
Okay, and is that with your Skipness Estate hat? Should I just check?
I would say that in this case, yes. Yeah, this one issue is absolutely that.
Okay, thank you very much for that request, which I will note. Okay, so beyond the issues that we've discussed, our party is happy for all other matters to be dealt with on the basis of the existing written submissions. So you'll see on the table that would relate to ornithology, access, traffic, transport, and other issues beyond the aviation safety. It would also cover any of the detailed aspects of the other topic banners beyond the detailed specifics that we have suggested. So anything else, basically, that anybody thinks should be dealt with for further process. Mr. James, your hand's up.
Me again, yes. Within the written submission we're making to you, we are requesting an additional inquiry under the topic of Section 15, other issues relating to issues of ethical misconduct and potential misuse of personal data. I've provided a written explanation as to why this is. We believe these issues are of the utmost importance in the determination of applications and the treatment of communities across Scotland. And that is why we are making a stand here. We believe it requires further investigation and in fact, legislative reforms to ensure that fair process and fair treatment of communities and adjacent neighbours to developments is ascertained. So we have significant objections here, and we've put it in writing. We would welcome the opportunity to present on this subject also. Thank you.
Okay, I would note that the inquiries, hearings, other further processes that we have are specifically to help us inform our report to the Minister on whether or not this particular proposal should be approved or not. With that in mind, can I ask the applicant's view on that proposal from Mr. James?
I'm not sure how it bears on the Scottish Minister's determination of this application. In terms of the process, I just want to flag on one thing. I've just come back to noise. There was correspondence that we had with the council on noise that you won't have, and we're perfectly happy to make that available. So it's not as if these matters were missed. I just want to make that clear, and we'll make that clear from correspondence in relation to the noise matters. And in social economics, again, we're happy to respond by way of writing. And I suppose in relation to ethical misconduct and data breaches, I don't think either are grounds for refusal of our Section 36 application. And therefore, I don't think they should form part of the inquiry. And it would be for the community council or whoever is making that accusation to put it in writing, I think. But I don't see how it makes or could be a basis on which it informs the decision making.
Okay, does anybody have anything further to say on that? Mr. James, is your hand still up there?
Yes, just to comment. We have we have put in writing our views on this subject, and we are requesting a written response from the governmental reporters on the subject. So we await that.
Through you, can I just seek clarification of exactly who the we is in relation to this submission and which hat Mr. James is wearing in relation to this matter?
Yeah, this is agreed between the Community Council that this is a reasonable ground for objection. I would also add, in relation to the applicant's previous point regarding noise, that we haven't received any data regarding the impact upon derelict sites. So we're still awaiting that.
Right, thank you. Just give me a second, please. Thank you for bearing with me there. I was just having a brief conversation with Ms. Hayward about how to incorporate your written statement into the process, Mr. James. So by the sounds of it, you're saying you've got a written submission on the topic that you've just been discussing that's ready to go. So if we could have that within this week, please, we'll be able to take that into account and respond as appropriate within the note of the meeting and seek any input from other parties if that's required. So if that's ready, that comes in at the end of the week.
That's absolutely fine. Thank you very much. It's much appreciated.
Thank you. Okay, so I think that is as far as we can discuss so far the manner in which we're going to deal with each of the topics where we need further information. And as I say, in writing up the meeting note, we will take into account the suggested changes and the other comments that we've had on that. Okay, so we've started on the next item a little bit already, but I'll just make sure we're absolutely clear on who is interested in participating in hearings or further written submissions, etc., on each of these topics. So, as I said at the outset of the meeting, I think everybody who is opted in to participating in any processes is here today. There aren't any other parties that have opted in but aren't present. The Loughranza and Catskill Community Association initially opt in, but they've told us that their organisation is no longer able to participate. As I believe I also said, we approached North Arran Community Benefit Society, who had been suggested as a potential alternative, but they haven't got back to us, and they had opted out, or they hadn't opted in earlier when invited. We've got comments on record though from both of those associations, which will be taken into account in the case. So just as a reminder, any parties taking place in inquiry or hearing sessions need to prepare and submit their cases in advance in order that other parties can see the evidence being presented and avoid surprises on the day. And for inquiry sessions, all parties will need to provide a recognition or inquiry report in advance and would need to be prepared to answer questions for the lawyers or representatives of other parties. Now, I know I've got parties potentially listed in that Appendix 1 table. This was me matching up the topics people had covered in their submissions with these topics. It's not necessarily the case that you all need to participate. So actually, as I'm going through now, I'll suggest who I think are the minimum participants, and then we'll see who else is interested in that topic. So starting with the inquiry session on landscape and visual impact. Is there anybody beyond the council, the applicant and Nature Scott that would definitely wish to participate in that? You raise hands if that is the case. Mr. James, and would that be for both?
I believe we're listed in the table as being a party and a participant. Therefore, we will participate. The Kintyre Way are also listed here as a participant, and Bob Chicken, who wasn't introduced, is also here in this meeting. So perhaps he might also wish to be involved in that inquiry session. Thank you.
Thank you. Yes, as I was saying, I have got people listed who I think may be interested. I'm just asking for confirmation of that today. So you are confirming for the Tarbert and Skipness Community Council, you would participate in that?
Yes, we are confirming.
Thank you. And Mr. Chicken, would you like to comment, please?
Yeah, I'm having some difficulty with electronics with my hearing aids at the moment, so please forgive me. In the absence of a very localised economic impact statement by the applicant, we need the applicant did an economic impact statement based on, roughly speaking, Earraghail and Bute. Kintyre is very different to much of Earraghail and Bute, and I believe there is a necessity to point out those differences. And therefore, we'd be happy, the Kintyre Way would be happy to take part in, would be happy to assist the community council with that part of what we're saying.
Okay, so it might be the case that you would like to combine together in giving evidence rather than participating separately. But that would be for you to decide. But I think that's what you're suggesting, Mr. Chicken, that you have similar evidence.
Yes, we do have similar evidence to the Community Council. And the Community Council did originally ask that a very localised economic impact assessment be made by the applicant, but they went and did what everybody else does in the area, and that's take it as being a part of the whole of Earraghail, and that Earraghail is very similar to Kintyre. That statement wouldn't be true.
Well, I'll note both parties down as interested participants in that inquiry. So.
Okay.
Thank you. Is your hand still up, Mr. James, or is that just from earlier? Okay. So the next is aviation safety. I have got down as the essential participants in that who are here would be the applicant in Glasgow Prestwick Airport. I have also noted down, and I've got them in square brackets, I think, NAPS, because although they have not opted into further process, we think their contribution would be helpful to that inquiry. And similarly, I note that the aviation safety is part of the council's objection, but you'll, in terms of technical evidence, would rely on the airport and NATS. Is there anybody else who would like to participate in an aviation safety inquiry, or are any of those parties I've mentioned needing to make comments?
Well, I think if I could just advert to my earlier comment, it would not be the intention of the council to participate in that inquiry session.
Would you intend to be an observer?
Dare say that might be useful, but I think I'll take advice on that. But I have clear instructions that we do not see that we would have anything to add at that particular inquiry session. A matter of technical matter between the airport and the applicants between themselves, and we would defer to their expertise that we brought to the inquiry by those two parties.
Thank you, Mr. Innes.
I've just got 2 points to make about this session. We're in advanced discussions with NATS over the mitigation in relation to their infrastructure, and if, as anticipated, that's resolved, I suspect they won't have an interest in coming. The second point, that in relation to this inquiry session, as the airport have indicated, there are ongoing matters. I believe that a formal statement of case would be a helpful provision in this inquiry session, because I think it's very important that we understand exactly what the position of the respective parties is before preparing the technical evidence that might go alongside inquiry reports and also the propositions. I am less inclined to think that is necessary in relation to the other inquiry session, which is the landscape and visual one, because I think the position of the respective parties in relation to that matter is pretty settled and we're quite clear. And I think in this instance, as has been alluded to by the airport, there is things that are potentially moving. And against that particular matter, I think there's a very real need to make sure that we understand precisely what the position of the parties is in advance of the technical evidence and the precognitions being prepared. And that will help influence the appropriate running of that particular inquiry session.
Thank you. Could I bring the airport in for any comments on this?
Yes, thank you, ma'am. The airport has no objection to that in principle, but the issue about preparing a formal statement of case just at this point is that until the dialogue has been concluded with the CAA, it's actually difficult for the airport to set out a final position on a formal basis in the way requested by Mr. Innes.
Well, I will note that. I'll note that down.
Can I just ask you to clarify that, Mr. Brown, to go a bit further in that? What are you expecting us to do if you have a position at this stage? Take this matter forward.
Yes, ma'am. Well, it may have to be that if it is something which you wish to make arrangements for, that the airport should be given until the end of November. Ma'am, the discussions are ongoing with the CAA, and there's a limit to how far the airport can press the CAA on the point. But until such times as I say, the discussion with the CAA has concluded, it is very difficult for the airport to set out a formal position in relation to the measurement of probability of detection, the measurement of adverse impact on VHF radio, and what may be acceptable to the CAA if there's an adverse effect on either their material points.
Mr. Innes, do you want to comment on that?
Yes, that's precisely why we need a statement of case. And we are not directly involved in those discussions between the CAA and the airport in relation to these matters. And it also slightly points, as I say, to my earlier submission as to why the airport should be going first, in that it's clear that the matters that they are potentially going to raise arise out of their direct discussions with the CAA. So I think the key point is getting a realistic timescale for getting a statement of case which sets out with some clarity what the airport's position is in relation to this matter, and in particular what they refer to as the potentially updated position relative to their ongoing dialogue with the CAA. So as I don't have that knowledge, only the airport does. What they're suggesting is there's going to be nothing before November, and of course it is also important to understand that post those discussions there may well be a need to evaluate matters, but what we want to have is fair notice. That's all we seek from this process, is fair notice of what we're having to look at and consider. And looking at the timing, it sounds like it's a Christmas present, which is not altogether easy either in putting together to respond to and consider. So as I say, it's not the easiest times of year, but what we need for this inquiry is absolute clarity, and that through the process will make sure that as the applicant, we're not constantly meeting an ever-changing position and that we can actually respond appropriately to the material that's being potentially presented. And that, in terms of a fairness of process, is all that we seek. So if the airport's indicating that it's unlikely to be in the short term that they can provide this, I think the key is making sure that the process that we set out and train provides the appropriate timescale for a statement, and then the appropriate time from that for us to evaluate that and to be able to respond by producing our technical report, which no doubt would come at the time of lodging documents in advance of the inquiry session. Because in this field, the plan conditions are very much a summary. It's the technical reports that really matter in response to these matters. And we need to know what we're facing, as opposed to as an ever-changing position, which is fully unsatisfactory and probably won't assist you in having efficient inquiry process. So, as I say, I think we're keen to make sure that we have proper advance notice, and we need to try and work out when that's going to be realistically available, and when the timescales provided that we can have a proper time to respond.
Mr. Brown, you mentioned earlier you were going to seek instructions on the suggestion from the applicant that you go first. When do you anticipate getting back to us on that as a first step?
Yes, within the period which has been allowed, ma'am, which is or discussed earlier, which is 7 days. Obviously, we're trying to get that as quickly as possible. I am informed, insofar as the matter of the CAA input is concerned, is that there is to be a preliminary meeting between the airport and the CAA in the middle of November. Now, it's obviously not clear what the output of that meeting will be, but if the airport was to be allowed until the end of November to produce a formal statement, which I agree would be useful. The airport certainly wants to know its case just as much as the applicant wants to know here, but there is a constraint on that. So if that meeting is in the middle of November, it is a preliminary meeting, so it has to be approached with that caveat. But if the airport could have until the end of November, that should be a realistic timescale for the airport to set out its formal position.
So we're obviously getting into discussion on the timescales for various procedures and documents going forward. I wonder if it would be helpful if we just finish up this agenda item, move on to the hearing and further written submissions, and just confirm who is definitely interested in participating in that. It might be worth then taking a short break before we move on to trying to further discuss the detailed arrangements, particularly the timings of what happens next, because that might take a little bit of time. So I'll press on that basis. So for the hearing session on national planning and energy policy, we have down here the applicant and the council. I think we've already discussed, the fact that perhaps the airport and Nature Scott would be participating in that as well. Are there other participants who would like to take part in hearing on energy and planning policy? Show your hands if you do. Nope. And similarly on conditions beyond the applicant, council, Nature Scott and Glasgow Prestwick Airport, are there any parties opted in who would like to take part in a hearing on conditions?
I think we might like to understand more exactly as to what that would mean should that outcome result, in relation to any modifications to design and so forth. I think that should it get to a point where those issues are discussed, the community council would wish to have an input. We're not quite sure what the conditions would be or what the terms of those conditions would be at this stage, but certainly conditions could make significant differences to community interests. So we might seek to be involved in that if possible. We would need to understand more as to exactly what is implied. Thank you.
Typically, the conditions are about agreeing measures that are to be taken to mitigate any of the impacts that have arisen. So in various of the consultation responses that are on the public website at the moment, statutory bodies and others have requested specific conditions. And I think I've discussed briefly earlier, there's a process the applicant goes through with those who've requested conditions to try and come up with a refined list. And we would use a hearing if there's any outstanding disputes on the detail of any of those conditions. So it wouldn't be something that is proposing significant changes to the scheme.
Okay. Well, if that's the case, then perhaps not. But we did offer some conditions within our own objection. So I guess we'd appreciate to be liaised with at least by the council on those matters.
Okay, well, I'll note that. Thank you very much. And moving on to the further written submissions.
Greg.
Sorry?
Mr. Greg's got.
Oh, sorry, Mr. Greg, I did have my head in the right direction.
That's all right. Sorry, ma'am. Just to say that NatureScot will reserve their position on conditions meantime, but they would appreciate if a draft set of those conditions, once available, could be circulated to them for consideration, and they can then decide whether or not they would have anything to contribute at the hearing session.
Thank you. Yeah, that's helpful, and obviously it's worth noting that the hearing session would only be required if there are still disputed conditions at the end of that liaison process.
Yes, ma'am.
Okay. Further written submissions on ecology. We've discussed this already. When there's any further process dealing with ecology, I have down applicant council, NatureScot, the Woodland Trust, and Tarbert and Skipness Community Council. Is there anybody else who would wish to be taking part in that? No. Okay, on archaeology and heritage, at the moment I have applicant, it's the wrong box, applicant council, West of Scotland Archaeology Service, Tarbert and Skipness Community Council. Is there anybody else for that topic? Okay. Socioeconomics, recreation and tourism, which, as I said, is specifically about the Skipness Estate proposal. I have applicant council, Skipness Estate. I've also got the Kintyre Way and the Community Council down. That was provisionally on the basis that it might be a broader topic, but with that just being focused on Skipness Estate, are we happy for that to just be the applicant, the council and the estate? Mr. James.
I was under the understanding, having read this, that this would be a discussion. This wouldn't incorporate just Skipness Estate's proposal. We understood as a council that this would incorporate the wider arguments surrounding Kintyre's socioeconomic impacts upon Kintyre. So I'm not sure if I agree with this being narrowly hemmed down to the specific issue relating to Skipness Estate's ecotourism and high biodiversity agroforestry proposals. I think a broader discussion is required, and we would welcome Kintyre Way to have an input to that. So we would be representing more broadly on simply the one proposal, although Skipness Estate will reply a separate written response in relation to that proposal specifically.
Okay, and sorry, I think earlier I did mention that we were interested in the Skipness Estate proposal. What I didn't say was that the reason I narrowed down the list from here is that on reflection, I think some of these issues probably cross over with the landscape and visual impact. Particularly, I was thinking about the Kintyre Way there, and I wasn't sure on the basis of the submissions that there would be specific aspects relating to socioeconomics, recreation and tourism that required further submissions. Are there any specific issues beyond the Skipness Estate project that you think should be, rather than these broad topics, any specific things within that would be useful?
Well, yeah, in that case, perhaps we could have a second category relating to the Kintyre Way's interpretation of how the development would affect the wider economics of Kintyre. In addition to their comments on the visual impact, they could also be given an opportunity to offer their thoughts here.
Shall we hear from the Kintyre Way themselves on that? Mr. Chicken?
Yeah. Yeah, indeed. I think we would want to participate in this. We are very concerned about the specific socio-economic effects throughout Kintyre. Bear in mind that the Kintyre Way covers a 100-mile path right the way through the 30-odd miles of Kintyre. So yes, I think we would want to be involved in this. We are currently carrying out a study on the future of the Kintyre Way. So yes, we would want to be included in this and believe we can make a contribution.
Okay, so if I just try and wrap that up in terms of how we would maybe keep it focused, it would be the socio-economic, recreation and tourism impact on the Kintyre Way. I guess that's consequential to the landscape and visual impact.
Yeah.
Okay.
I did note also there were comments invited in relation to the landscape and visual regarding the maritime scenic qualities. Again, you know, this is an area in which we believe that the confluence of socioeconomic interests and landscape and visual impacts is of relevance. So there may be some comments put forward regarding the socio-economic impacts of the combined maritime tourist economy that spans both Arran and Kintyre. So again, you know, this is something that, including, you know, the ferry routes, the recreational boat use and so forth, something we feel is under well, without going into the details. Yeah, I think there's a confluence of these two issues in various places. So we'll probably further some thoughts there as well. So certainly the comments from the council and from the Kintyre Way likely will go beyond simply the ecotourism application and the Kintyre Way specifically.
Yeah, the further written submissions will be on specific issues within the topics. So it won't be what's everything that people want to say on this. We've already got a lot of that within the written submissions, and we have to take those into account already. So the purpose of any of these further procedures, whether it's a written one or an oral one, is if we require specific information in follow-up to what we've already seen in the evidence.
Okay. Well, I understand. I don't want to burden you needlessly. We did just note the comment regarding the maritime scenic qualities and believe there might be a comment there to be made. So just wanted to flag that up.
Yeah,
it won't
make
a big thing of it.
And that's on the list, of course, for the inquiry.
Yeah.
For the landscape and visual impact inquiry. At the end of the list of written submissions and participants, I'm going to take a break now. Before I do, are there any final comments on what we've discussed so far in terms of how we do these topics we're going to deal with and who needs to be involved? Or have we done that?
Just finally, ma'am, just to reiterate my request for the biodiversity enhancement for the written submission, in case that would be helpful to ensure it's not lost sight of.
I think when we come on after the breaks talking about the timescale, bearing in mind, I think there was a request for that to be provided early. We can look at where that best fits in. Okay then, so we will take a break. We've been going for nearly a couple of hours. I would suggest we come back at 1:45. That's okay with everybody. So if you want to, you can put your cameras and microphones off for now, and I'll call us back 1:45. Hello, thank you all for being back. Sorry, I'm a couple of minutes late back myself. We'll resume the rest of the agenda items now. Before we move on to item 7, we were on item 6 before the break, which was where we were talking about what sessions or further submissions we'd have to cover the various issues that we'd listed. Ms Hayward and I would like to suggest that in addition to the sessions that we've already talked about, it would be helpful in this case to have a community hearing. The purpose of a community hearing would be an opportunity for the community bodies, so in this case that would be the Skipness Estate, Kintyre Way and the Tarbert and Skipness Community Council, to make sure that we as reporters are aware where and why your organisations have disagreement with the evidence that is already before the inquiry. So that would enable you to cover any points that aren't already covered in detail in the inquiry hearing and further written submissions that we've already suggested. So the nature of that is it's not a procedure that involves cross-examination, but it does mean that you would be able to directly air all of your issues, make sure that we've heard all of those issues, and it also comes with an opportunity to provide a formal written statement on those matters. So could I take parties' views on whether that would be helpful? And I will start with you, Mr. James.
Thank you. Yes, I think that would be incredibly helpful. I would state, however, that I will not be able to attend in person until a date close to the inquiry date, because I am working abroad for a period of time. But I could proceed with that virtually and provide evidence in that method. But I would need significant time, as much time as reasonably possible to do so.
And we'll come on to the dates in a moment, so you'll know everything today. That would be Mr. Chicken. Would that also be for the Kintyre Way?
Yeah, that's perfectly acceptable for us.
Mr. James, it's you're representing both the Skipness Estate and Tarbert and Skipness Community Council, aren't you?
Yes, Paul Crone, who's here present at the meeting, is representing jointly with me on behalf of the Community Council. So we are both representing in that regard. I'm the elected representative for matters concerning energy development by my council, but I've enlisted Paul to assist in this so that we can more accurately represent, and there isn't accusations of conflict of interest and so forth that are unreasonable.
Okay, I'll put both names down for potential then. Can I open for comment or question to the other parties? I'll start with the applicant, please.
Madam, I think that's an entirely suitable format to enable those views to be gathered, so we'd be supportive of that.
Thank you. And the council?
The council is also supportive of that. Thank you, Mum.
Okay, would anybody else like to make any comment or ask a question on that before I move on? Okay,
just before you do move on, going back again to the question of participation, I've taken instructions with regard to the aviation safety inquiry session, and in response to your earlier question, the council would be happy to observe that particular session. If called upon to clarify matters, we'd be there present, but I don't anticipate that would be required, but we're happy to observe to answer your question.
Okay, thank you for confirming that. Okay, I will move on to agenda item 7 now then. This is where we look at the dates, locations, likely duration of hearing and inquiry sessions. And then after that, we're going to move on to the dates for the further process, which we may need to work on together. So, first of all, I would like parties' confirmations at this point on whether the inquiry and hearing sessions should take place in person or virtually. Doesn't necessarily have to be the same answer for all of the sessions. So I will start with the applicant, please.
Thank you, Madam. We consider that in terms of certainly the inquiry sessions, that they should be held in person. In terms of the policy hearing, we suggest, given the numbers of parties participating, the length, probably in person. Conditions probably doesn't need to be in person, and those are the only procedures. In terms of length, probably across the year, we consider the landscape and visual impact would last up to 4 days. We consider that the inquiry session in relation to aviation is likely to last 4 days at least, given the number of witnesses involved. Although at this stage, not knowing what exactly is going to be raised, that is a slight finger in the air. But at best, I think at least 4 days would have to be provided for that. In relation to the policy session, we don't think it will last a day. It'll probably be within the day, is our general experience, given that these matters are now relatively focused. And the conditions hearing session, we think, is likely to last a maximum of a couple of hours.
Okay, so we'll come on to the community hearing and time needed for that later. But for now, on those suggestions that Mr. Innes has made, can you put up your hands, please, if you have any differing views on how long any of those sessions might take, or whether they need to be in person or virtually? Okay, Mr. Brown, the airport.
Thank you, Madam. So far as the inquiry session on aviation matters is concerned, the airport would be content with a virtual session for that.
Okay, that's helpful to know, thank you. And Mr. Gregg?
Thank you, ma'am. From Nature Scott's perspective, their preference would be for the sessions in which they are involved to be virtual. They've had experience of virtual sessions and meeting with success covering these topics previously. In terms of timescales, I think Mr. Innes is correct that policy shouldn't last more than a day. And in terms of Nature Scott's interest in the LVIA session, whether that's separated out into a separate NSA session or it's included in the wider LVIA session, I suspect that perhaps up to 2 days, considering NSA impacts, would be appropriate.
Okay, which would leave up to 2 days for the wider issues. Mr. Carroll, is that about right?
Yes, I think that sounds reasonable.
Mr. Carroll, what's your views on in person or virtual?
I think there is a tendency amongst hearings of this kind to be in person nowadays. It's certainly been my recent experience. The whole point about having a public inquiry is so that members of the public can attend and to be participants in a essentially democratic process. It is something that affects them and their community. So I think it militates strongly towards an in-person hearing for those substantive matters that have to be dealt with. Having said that, I have no objection to it being held virtually, but I would agree with Mr. Innes that in-person should be the first port of call if that's something that can be done. In terms of duration, I think overall the duration, yes, I think 4 days, however you divide it up, would probably be enough for landscape and visual. The inquiry session for aviation, well, I defer to others on that particular one. Obviously, timetable would be an issue if that's to be a hybrid inquiry with the aviation safety issues dealt with virtually and the rest dealt with in person, then clearly it makes sense to have that at the end. But that's a matter for the reporters, obviously. I just simply put that as an observation. Policy session a day, I agree with that. And the condition session is, I think I also agree with an estimate of 2 days, certainly no more than half a day is also my recent experience for the requirement for that.
Thank you. Mr. Innes?
I've just got one point to make in relation to the aviation session. If we do have an aviation session, it will be technical. And in my experience, that is best based in person. It is more effectively done in person. The second point that might arise is we still don't know what issues are going to be raised at the aviation session and what other parties might need to be present. But if it's restricted to the applicant and Glasgow Prestwick actually participating, then there might be the opportunity to hold that inquiry session in a location that perhaps was less rural and more closer to where, for example, the airport witnesses are likely to come from, and perhaps be easier to find a venue. I just flag that, where if we had a very technical issue based on basically Glasgow Prestwick's issues, then I think there is some justification for looking perhaps for a venue in the west of Scotland for that session, rather than Argyll Butte, where we're going to obviously come on and talk about the availability of venues. But that might, in essence, reduce some of the travel requirements that are associated with participation from the airport interests and others in relation to that session. I just pose that as a very discrete session on a one technical issue. And it does seem that it may make sense to hold it in a location where more of the technical witnesses are likely to come from and be easier to access.
Okay, thank you for those. Thank you for those suggestions, which we'll be able to consider. Can I just ask the community representatives, Mr. James and Mr. Chicken, are your preferences for any events that you're participating in to be in person or virtual? Mr. James.
I think the inquiry session on landscape and visual impact should be in person, on the basis of the points outlined by Morris. Really, I just believe that there is a case for people being together. So that is my preference. In other respects, I don't see the need for that for anything else that concerns us.
Okay.
Potentially for the hearing process, the community hearing, it might be useful, but I'm not sure if I could, depending on the time frame of that, it might be necessary to be virtual.
Okay, yes, thank you. And Mr. Chicken, have you got any views?
Yeah, I strongly believe that they should be held locally on the same grounds that Mr. O'Carroll quoted earlier. They should be in public and be seen by the public.
Thank you. So I've got everybody's views there, so that's helpful. Helpful to know what everybody thinks on that. I'm going to move on to locations for any in-person sessions. We had a few suggestions in, I think, from the applicant and from the council. There were two that people haven't seen any sort of reasons against. One is Stonefield Carrefour Hotel, Tarbert, and the other is Tarbert Village Hall. Do any parties have any other suggestions or comments on those venues? Please raise your hand if you do. I will keep those in the frame as the potential location. I was going to come on to duration next. We have done that.
If I could just intervene, just in terms of, no doubt your team will investigate the suitability of the venue, both for having adequate number of access to electricity and Wi-Fi, are probably two prerequisites for an inquiry session. And it's just, for a landscape and visual session, there are going to be quite a number of parties. I think a lot of us will be using laptops, and therefore it's that basic thing of, are there enough power sockets to actually accommodate us? But no doubt your team will be pretty experienced in understanding whether a venue would work or not, because there'll obviously be a necessity for their equipment also. But it was just the one thing that probably needs to be checked as to whether the venues actually have the basic requirements to be able to hold an inquiry session.
Thank you. Mr. Gregg?
In a similar vein, ma'am, Nature Scott might have some difficulty with fielding a policy witness for an in-person hearing session. So if that is to go ahead, that's certainly something that they can look at again. But I wonder if there would be scope in that instance for that that witness joining virtually and having a hybrid session. That will obviously depend on the reporter's preferences and the suitability of the technology in the venue. But I just flag that depending on where we get to.
Okay, I'll flag that potential request. That's specifically for a policy hearing.
Specifically for policy, yes.
Okay, thank you very much.
Thank you, ma'am.
I'm going to move on.
Mr. Chicken's got.
Oh, sorry, I keep looking down at the wrong moment. Mr. Chicken.
Yeah, given the need for connectivity, you might want to look at the Templars Arts and Leisure Centre in Tarbert itself.
Okay.
The ALC. Known as.
What's that? There's something. What's the name of the Arts and Leisure Centre? Tempus.
The Templars. I think it's the Templars Arts and Leisure Centre.
Okay, that's helpful to have an extra suggestion. Thank you very much. Thank you.
In my past experience, the applicants have been able to provide specific Wi-Fi facilities themselves in addition to those existing in order to facilitate Wi-Fi for everyone. I'm not sure if that's possible in this instance.
Is that possible in this instance, Mr. Innes?
We'll give you every assistance we can once we've identified a venue and can look at what's achievable. We certainly have teams that have expertise, so we'll no doubt be able to assist if that would be an issue.
Thank you. Okay, I'm going to move on to dates. I'm just going to check any more hands up. Okay, so the thing to be clear on before we get on to discussing the dates is we're required to work on a timescale where we deliver a report making a recommendation to ministers within 50 weeks of us receiving the application from ECU. So we're allocated the allocation. We have 50 weeks to basically do our stretch of the work on that. So with that in mind, we had set out in the agenda provisional timescale for oral sessions, and that was week beginning the 5th of February, which is what we have in mind. So my initial question to parties is, with all that we have discussed, how achievable do we feel that is? And if that isn't achievable, what date would be? So we have a bit of discussion on that. I'm going to start with Mr. Innes, please.
Thank you, Madam. I think the date's probably unachievable if I'm just going through the various matters that have to happen. And there's probably two matters that are going to potentially impact. One is sort of standalone, and that's the aviation issue. If I start with that, if it's likely that the press are only able to clarify the position by, say, the end of November, beginning of December, I would anticipate that, given Christmas, it might take us towards the end of January to be in a position to understand and have consulted and potentially produce information. So I would have thought that then directs that the earliest time that reports could be produced would be towards the end of January, beginning of February, and then thereafter has to be preconditions. So that just doesn't look achievable for that particular aspect. But obviously, that is a very discrete topic that can be timetabled to occur towards the end of any process. So that may well deal with that one. The second issue is the timing of our issue with Turbine 5. And as I say, we need to go through the process, first of all, checking that there has been no infection of any assessment. Secondly, we need to go through a process of reworking the mitigation scheme over lighting. And then we also have to produce the information, the additional information. And as I say, I think on a best view, that's achievable roughly within a month. But if there was something more substantive in an assessment chapter, that might extend it a bit. Thereafter, there'd be 30 days in which constituents could respond and members of the public. And thereafter, obviously, parties will be free to present and prepare the respective cases on any matters that arise from that. Now, it may be that it's just unknown at this stage as to the extent of whether there is an issue or not, but it would seem to me that it might be appropriate to ensure that we timetabled that there was an issue that people wanted to address, and therefore that puts essentially, with Christmas and everything else, into a very, very tight timescale to be producing material effectively for a commencement at the beginning of February. It seems to me that that is not possible within that timescale, and it suggests that more mid to the end of February is realistic for other issues, and that would be certainly into March in relation to the aviation matters. And I suppose the second point about it is that I think until those environmental issues are resolved, it probably wouldn't be that safe to entirely predicate all written submissions in case there was any bearing on it. But there is, of course, nothing to stop the written submission proceedings at dates which aren't tied to inquiry dates, because they are effectively a process. But obviously we'd have to go through and make sure there was nothing in the material that was anyway affected or could be infected by T5, and therefore would be free. But I think that there is nothing wrong with some of those written submissions potentially coming forward, but probably at a time at around after that time period for the response to the any additional information or that's been submitted, and that could start, because usually as a written submission process will be provide for the exchange of written submissions and the opportunity for parties to respond. Well, that does seem to be sort of doable if written submissions has to be in around the time of the end of the assessments, so sometime in December, and then an opportunity to respond to any written submissions being timetabled. So that seems to be that keep that momentum going in terms of the written submissions, and really the policy and other matters obviously are tied in with, to a degree, some of the evidence in relation to inquiry sessions, so probably sit quite closely aligned. And equally, I see no reason why we can't actually progress matters such as conditions in the interim to progress matters. So I think there's quite a lot that can progress, but I think there's aspects, as I say, of the inquiry process which, until we've resolved, because, for example, the reduced lighting scheme, NatureScot need time to consider and evaluate the material that responds to that and consider their position in relation to the nighttime lighting effects. So it's not just getting that material, it's a chance for NatureScot to properly evaluate it and come back. And it's from that process that we then start narrowing issues and trying to reach statements of agreed matters. So there is an element that there needs to be a period of having the material, statement of agreed matters, and then we proceed to an inquiry process that hopefully is narrowed down and focused. And that process probably needs to allow for that. So I've set out the best I can based on the information I have available today. My number one priority at the moment is ensuring that our information that we have in front of the AAR is accurate and that there's no problems there. And we need to get that resolved sooner rather than later, and then embark upon that process of resolving whatever may happen arising from the unfortunate coordinates of T5 and table 3.1.
Okay, I'm going to try and do a summary. I'm not promising I'll do it brilliantly, but you can tell me if I've got anything really important wrong. So based on the things that are within the applicant's purview, best case scenario is you would need a month to go off and do the work that you're going to do before you submit anything to us. And then we have a 30-day period, so basically another month.
Yeah.
So it will be 2 months before we're at the point of knowing back from other parties what they think of what you're going to produce. Okay. And based on that, you think it's late February for oral sessions that are reliant on that additional information. And it might be later if unexpected things arise during that process. At best, late February for session on that. And at the end of that 2 months, the month and 30 days, you think at that point it will be safe to commence the further written submissions, because any that are reliant on that information, the information will be there. Beyond what's in your gift, the information you're expecting back from the airport, based on what the airport have told us about their timescales, you think that will mean the inquiry session relating to aviation safety will need to be later, probably into March. Is that a fair summary? Okay.
That's a very fair summary, Madam. Thank you.
Good. I'm pleased. So based on that, do other parties have any comments on those timescales? I'll let you put your hands up if you do. Mr. O'Carroll.
Yes, for the council, I appreciate Mr. Innes's difficulties, fully understood, and also in relation to both aspects of what he's just addressed the inquiry on. The council wasn't aware of there being any reason for delay before attending this morning. So on that basis, we had cleared everything to commence the oral sessions on the 5th of February. And we had agreed that with our witnesses and with myself that we were all quite happy to commence on the 5th of February. And indeed, that was our strong preference. So we did want to accede with the suggestion that was contained within the agenda for today's meeting. So having said that, and the difficulties that have been ensued, obviously we can't have an inquiry if people aren't ready, and if there's an important matters that can't be examined in an inquiry, then it's pointless having one. So that's a given. Given what Mr. Innes has said, I would just say though, then in answer to your further question, and if the further point then, Mr. Innes is suggesting that we'd commence at the end of February. Well, another reason for the 5th of February being the clear council preference is that there is not availability at the end of February for the council, but there is availability in March, starting from the week commencing 4th of March, if that was then decided to be the most likely and realistic date. So I'd only say that the end of February is out, if indeed the 5th of February is not a realistic date, as Mr. Innes says.
Okay, so it would be helpful to know whether other parties that are due to be participating in the oral process, which is across them is, I think, is all of us in some form or another, is the week commencing the 4th of March date that works for others. Can I start with Nature Scott? Yeah.
Thank you, ma'am. Nature Scott find themselves in the same position as Mr. O'Carroll in terms of we were good to go for the week commencing the 5th of February. I would need to check witness availability if that's to be significantly later in the year, whether that's late February or early March. I'm not going to be able to do that on this call, unfortunately.
Okay, it might be better for us to put out a call for availability across March then, if it looks like we can't have anything in late February. It would maybe mean everything shifting into March. So is everybody agreed that that's, presumably everybody can't give me their availability in March today?
I can. I think March is okay for me, and also if it also says Mr. Gregg, that one of the reasons I know March is good is because my landscape witness has indicated she's available in March as well.
Okay.
That is of assistance.
Yeah.
I will need to check with the wider team, of course.
But you've obviously got a wider team, obviously.
Okay, Mr. Innes?
Yes, we'd be good to go on the 4th of March in respect of landscape and planning. What we don't know is, because we don't know what the aviation case is what exactly is going to be required in terms of witnesses to respond to whatever aviation case comes forward. So that we would need to check.
Yeah, I think we're separate to aviation at the moment. Although you said initially that
we can do all the other stuff we can do in March, beginning on the 4th.
Okay, Mr. James, do you know if you're available on the 4th?
Yes, that date shouldn't be a problem.
Okay, and remembering actually, we did earlier say there'd be quite a few days involved, so it's not just that date. It's
understood. I did note the comment regarding written submissions. Is it my understanding that they would the expected day of those would be at the beginning of February? Was that the proposal there?
So we would be requesting those, I think, at the end of 2-month period. So then there would be it's usually, is it 14 days? I'm going to double check. Is it usually 14 days? Yeah, so it'll be 14 days, but obviously we could take into account the Christmas period. So, because we'll be pretty close up to Christmas by the end of two months.
Yeah, well, does that mean a date in early February then is anticipated?
No, the 2 month period would be the month that the applicant requires to decide whether or not there's going to be any implications for the error they've made on turbine 5. So that would be a month for them to decide that and produce their information. And then 30 days period for consultation on that additional information as a statutory period that people have to consult on the new information. And that's basically 2 months from now. Was when we would anticipate starting the further written submissions process. So 2 months from now, where are we now? October, November?
It's the 12th of December.
Yeah, 12th of December.
So that would probably,
be back after the New Year period then.
Yeah. We'll confirm it in the note, but I would anticipate a date in January rather than December.
Okay, well,
so without.
It could be staggered potentially if there's numerous ones as well. You have to, as we pointed out earlier, we are unpaid volunteers. We do believe we have a right to participate. So delivering a large volume of work on multiple areas, we might need to stagger the submissions. But if a date beginning in mid-January would be acceptable to us.
Okay. So what would have happened if we hadn't had these delays that we're talking about and additional information? What normally would have happened is that the request for further written submissions would have started alongside the note of the meeting. So basically by 3 weeks today, we'd be looking for information. So instead, that'll be in January. So
okay, well, that's beneficial from our perspective. So we're happy enough with that. Thank you.
Okay, and obviously when we get back the additional information, if that is unusually voluminous or complicated, that is something we could take into account in whether we give any more than the standard 14 days for responses. So we don't know that yet, but we can look at that when it comes back.
Okay, thank you.
Back in. Okay, do you remember where we'd got to? So we were looking at potentially 4th of March for the beginning of the sessions, oral sessions that are not tied to the aviation information. And we're going to have to tie up the specific dates outside of the meeting. In terms of the dates we can be clear on, the early ones in the process aren't necessarily affected. So I think I've said earlier, I'm committed to getting a note of this meeting out by a week today, so Thursday the 19th of October. The next date that I had down in my previous meeting schedule was the 26th of October, which is 2 weeks today, for any statements, agreements, sets of conditions and draft core documents lists. To what extent, Innes, would that be affected by the separate work that you are undertaking?
Madam, in terms of getting the CD list and the conditions ticked off, absolutely not. I think that we can kick off with that. Yeah, absolutely. Statement of agreed matters probably has to wait, or otherwise we could be a moving picture. I would say the statement of agreed matters could probably kick off once we've lodged additional material, because it's a process, not a one-off. So we could start that process because at least the parties then know, are there any issues arising from T5? Is there anything else? And we could start that process. So I genuinely think we should start that process, because the earlier you start it, the better the outcome, because it does take time to exchange drafts and going back and forth. And I do think statements of agreed matters are very helpful. And I do think it's what can really narrow down the issues and work. And as I say, we do have prior experience both working with the council and Nature Scott on these matters, and would be very keen to progress it with other parties where that's possible. Aviation statements of agreed matters probably less certain, because it can only really start to be considered at a later date. But those core ones in relation to other sessions, I think we could easily start kicking off at the point of sort of mid-November, so that we're getting ahead of the time rather than waiting. Because we go and have Christmas and then you're starting in mid-January. It seems to me we want to kick those processes off at an early stage of the process to make sure that we get the most available time and get the best statements of agreed matters that we can get for you.
Okay, thank you. That's helpful start so far, I think, in terms of agreeing that we'll get what we can underway without delay, and the additional information work is hopefully only going to push back the oral sessions for those topics by about 1 month. Coming back to aviation then, so presuming we are sort of slightly decoupling that from the process we've talked about, are we able to firm up when we might get to a point of being able to have a inquiry on the aviation, when we might be able to catch up on the aviation issues? Does either the airport or the applicant want to moot a possible time frame?
Yes, ma'am. Yes, ma'am. Thank you. Ma'am, I appreciate that the principal issues will be addressed in the inquiry session at the start of March, but I would have hoped that it would be possible to start the aviation session fairly soon after the conclusion of the inquiry sessions on landscape and visual, etc. The other constraint, of course, is that as we get towards the end of March, the school holiday period will start again, which is likely to be a fortnight, which would potentially cause difficulty for witnesses. So I would propose, ma'am, that maybe the third week in March is penciled in for aviation and can be reserved in the parties' diaries, if that suits the applicant, and of course you, ma'am, and Ms. Stewart as well.
So that is the week beginning the 11th of March. Is that the one, or the 18th?
I don't think the airport's got a preference for one over the other, ma'am.
Okay. Well, if I'm going to come out and ask for views on availability early March, I'll just extend that through the rest of March for the aviation session. But those 11th or the 18th, Mr. Innes, is that broadly in line with what you were anticipating being likely achievable?
Yes, madam, that's exactly how I anticipated it running on, but again, we'll test the availability.
Okay. Well, I can profile a timetable working back from those provisional windows that we've identified for the oral sessions. I can do that and set that out in the note of the meeting if people are happy for me to do that separately rather than all live now. Yep. Okay. I'm just seeing if there's any general points.
Greg's got a hand up.
Oh, sorry, Mr. Greg.
There's just one point on the timetabling. My own view is that it might be helpful for the landscape and visual impact session to have statements of case prepared for that, to set out parties' positions so that everyone's clear as to what's proposed going into that session and what witnesses are being led and all the rest of it. I've always found that a helpful approach.
Okay, so just for anybody who hasn't participated before, that would be a written submission that would just make it extra clear for everybody participating what people were coming to discuss and who was coming to discuss that. So would anybody who's participating object to that, or otherwise I will write that into the programme?
Well, Mum, I think we have discussed that. Mr. Innes has discussed that point exactly earlier on. And I happen to agree with him that the actual points of dispute are well known between the parties. Certainly for the council's objections been set out in the report of handling, and that's well known to the council and to Mr. Innes for the applicant. Equally, Nature Scott's own position is also clear, and particularly from today's discussion as well. So I'm wondering, I mean, I'm not totally averse to it, but I'm wondering if it really just adds an additional level of procedure and resources being used for something that may not terribly much assist the inquiry.
Does anybody have a view on whether it might be helpful in relation to the parties that are less commonly involved in inquiries?
I just raise it as a suggestion, ma'am. I think it might be helpful, but it's a matter for yourself.
We'll think about that then and confirm in the note of the meeting you'll see whether that's programmed into the timetable or not. A couple of general points that would still apply. One is closing submissions, where we do have oral processes. We'll be happy to take closing submissions in writing after those have happened, rather than within the oral sessions themselves. So it's just a point to note that might help when a time comes to prepare for those. One additional point to flag now is that to help streamline our reports and speed up decision making, we now ask parties to provide us with written summaries of their cases, particularly in relation to technical matters. So here, like the landscape and visual and aviation matters. And we will ask for that to be done alongside closing submissions. So that's just a recent addition to our process that I'll flag up for now, so it's not flagged later. I think there's much more we can do on dates or the process at the moment. So unless parties have any other comments on the dates and the timeline, I'll move on. Okay. Agenda item 9 is site inspections. So very behind on scrolling dates. So our initial proposition is that Ms. Hayward and I will carry out unaccompanied site inspections in advance of the oral sessions. We're going to visit a number of the viewpoints and locations referred to in the application, consultation responses and your representations. We haven't at this stage identified any locations that we think have to have an accompanied site visit, but we would like parties to advise us as soon as possible if there are any such locations. So if you think that when we go and do our site visits, it would be helpful for us to be accompanied in any specific locations, please let us know that in writing by the end of the 26th of October. It's a couple of weeks' time. And we will then try and accommodate that, whether that's alongside our unaccompanied site visits or a separate later date. Equally, if you are content that only unaccompanied site visits are required, if you can confirm that, that does help us as well. For now, whilst we're here, if there are any particular viewpoints or locations that you want to be sure we are programming into our unaccompanied sites inspections, please let us know. Are there any specific suggestions people want to make sure are on the list? Hands up if you do. Mr. Gregg.
Thank you, ma'am. Can I propose that take instructions on that, and NatureScot can perhaps provide its advice to you by that same deadline, 26th of October, if that suits.
Yeah, if anybody needs to take advice on that, the 26th, you can, yeah, unaccompanied, either recommendations whether they're fine. Mr. James.
Yes, in relation to the Skipness Estates proposal, it might, it is an important consideration. We have put forward the location previously and received a wireline from the applicant. I don't know if it would be of interest to you to visit this location. We are awaiting information from NatureScot. So, it's difficult for me to say whether it's of relevance to you, but certainly it's important to us. Whether it figures in the inquiry is difficult to say. I mean, whether it's relevant to you, it's hard for me to say, but we certainly wish it to be considered. So in the event that you did want to go there, it would require accompaniment because it's difficult to access, but potentially. Yeah.
Okay, are you talking about a viewpoint or a location that's already?
It's a location that's already configured, the derelict building in question proposed for redevelopment.
The derelict building, okay. You don't happen to know the reference number for that, do you? I'm sure I can find it.
Well, you mean a grid reference? No. I can send it to you shortly.
Okay, well, if we can't identify that in the viewpoints and wirelines that we've got, we will ask for clarification.
Okay. Yeah, thank you.
Mr. Paul, I haven't got your surname written down. Paul, do you want to come in? Oh, you're frozen.
Yes, Paul Crown, can you hear me?
Yes, I can.
Just to say that if you need accompaniment whilst Rupert James is away, and I can stand in to assist you.
Okay, that's helpful. Thank you for that offer. Next, I have Mr. Innes.
Yes, thank you very much. Just insofar as if you wanted to go on the application site, it is readily accessible by a vehicle of reasonable robustness. And I suppose the only thing about it is it's Forest Land Estates, and there are restrictions in terms of what you can and can't do on site with permission. But one of them is if you're going on site, you need to be accompanied by with various equipment and an appropriate first aider. So if you want to go on site and it's got I think you may want to do this, we can arrange for permission to be granted, but you will have various things that you need to provide with, spill kits, first aid, etc. You have to go through a bit of a rigmarole, and it's just the way they've got a standard procedure for any vehicles going on site and anybody going on site. So just to say that if that was something you wanted to do, then we certainly can facilitate that, but it's important to think that there's a number of hurdles and processes that you would have to go through. And it is quite a large site once you get up there. So, but there is good access. So the point is that it can be quite efficient to actually get up there by vehicle and do whatever you want to do at viewpoints, etc. But equally, you probably have to think a bit about it, and we can certainly assist and with FLS if that's what you want to do.
So does that apply to the whole of the site, including the access track?
If you're going on with their permission.
Yeah.
Yes.
And does that extend beyond the red line of the site to the wider, if there are any viewpoints in the surrounding part of the estate?
Well, strictly speaking, of course, if you accessed it without getting their permission and just did it through access rights, etc. But if you're going to access it via a vehicle with their permission, you will have to comply with the strictures of what they impose. And as I say, these are standard for anybody going on site with a vehicle, and that's the only thing it is. But it's a large site, and having a vehicle will mean that you can get round quite a lot of the issues, including potentially visiting other parts of the site, including possible suggested locations effectively and efficiently. So it probably has advantages, but it probably just needs a bit of forward planning.
Okay, thank you. Thank you for that advice. Mr. Chicken, your hands up.
Yeah, there are one, maybe two locations on McIntyre Way that I think would be well worth a site visit. I just need to confirm that with one of my colleagues before I can take that any further. I can get a written reply into before the 26th anyway.
That's fine. And any of you who between now and the 26th of October think of a site that you think it's essential we visit, just let us know, and let us know if you think that needs to be accompanied or not, and then we can take that into account in our final planning. Thank you very much.
Thank you.
Okay, I'm going to move on to agenda item 10. All I need to note here is that Jane Anderson is our case officer for this application. I think most of you will have already corresponded with Jane She'll be your main point of contact throughout the process. She'll liaise with Ms Hayward and I as necessary, and it's Jane who ensures all relevant documents are circulated and made available on the website as required. And finally here, as mentioned, we hope to issue our note of this meeting within 1 week. Now, I have come to the end of my agenda. I think I've skipped an item, so give me a second. I can cover it from memory, it's okay. So this is just an update on how we manage our documents. Recently, for oral processes, we have been able to distribute USB sticks to people participating in oral processes with all of the key documents on. We don't do that anymore because it has raised security issues. What we do instead now is we use an online document sharing tool called Objective Connect. We upload all documents to that in advance of an inquiry or hearing, and all participants are given access to that, and our IT and admin teams provide guidance and advice on how to use that. That's in addition to all of the documents also being available on our public website. So that's just a point to flag. Does anybody have any comments, questions on that?
I do.
Yeah.
I do have a personal comment on that. I don't like Objective Connect. However, when I did the shade room inquiry with Mr. Innes acting for the applicant, he very kindly circulated a USB stick with all of the relevant documents on them in a format which was very easy to access. So I appreciate that the DPA has its own point of view with regard to that, but I wonder if I could prevail upon Mr. Innes to make that available to the other parties as he did before.
Can I just interject at this point? We want the DPA should be in control of the documents for the inquiry.
No, of
not
course
the,
they should. Yes, yes, absolutely. I appreciate that, but this would be in addition to. I'm not suggesting any usurpation of what their role would have in terms of documents.
Well, I think that should be a private arrangement between yourselves and the applicant.
Yeah, that's what I was
We wouldn't get involved. That we wouldn't get involved in, but we are, as far as we're concerned, we'll be providing documents on Objective Connect. Whether you can use it or not is up to you.
Yeah.
Okay. Thank you very much for that. I think we've come to the end of the meeting because agenda item 11 is any other relevant matters. So before we finish, do parties have any other relevant matters they'd like to raise that we haven't covered already? I will take hands rather than going around the rooms. No? Okay. Thank you very much.
Mr. James. Mr. James.
Yeah, just to say that we will be submitting our written response within a week as requested. The document we intend to provide to you too. So we can, is that to you, Tammy? What email address should we use?
To Jane Anderson, the case officer.
Okay, thank you very much.
You will have corresponded, or colleagues from your organisation will have corresponded with previously.
Okay. Thank you very much.
Okay, thank you all very much for participating and helping clarify where we've got to. I will get back to you all with the meeting note within a week. You get back to me by the 26th with suggestions for site visit locations, and otherwise we will proceed as agreed and as I will note in the timetable. Thank you all. Bye.
Thank you, ma'am. Bye.
Thank you.